Hello, my name is Bruna Frota and I am a US licensed attorney in New York and Texas, and I have been doing a series of videos about employment-based green card categories, including the procedural aspects of adjustment of status application and consular filing applications. My first video was about EB-1 and EB-2 self-sponsored green cards, and today I'm gonna focus on the EB-2 and EB-3 when you have a company that is sponsoring for you. My second video was about the procedural aspects, as I discussed before, and you can refer them to just go to my website at www.nationalitylawyers.com, where you can also find more about my background as well as reviews. But then you can self-educate yourself on the procedural aspects and the other types of green cards that my series are covering throughout the months during the year of 2019 and first quarter of 2020. As I said, today I'm gonna covering the labor certification process, as well as just touch base on the I-140 immigrant petition and the consular filing or adjustment of status, just in general terms, because if you need more details on the procedural aspects, refer to my previous video, the second one of the series. But today, as I said, we're gonna go through the labor certification, which is, in other words, a labor market test of a position that the company would have to justify that there are no US citizen or green card holders available, willing, or capable of undertaking the position that company is offering to the foreign alien. The EB-2 green card category is designed for advanced degree professionals, which are professionals that have at least a master's or bachelor's degree plus 5 years of experience, and in the case of some people, exceptional ability. And of course, the position also require at least those qualifications as a primary requirement or as an alternative requirement. And the EB-3 is for professional, skilled, unskilled, and other workers. So any other position that the company is sponsoring for, and it does not require a master's degree or a bachelor's plus 5 years of experience or the exceptional ability, as I explained before, would fall under the EB-3. So for some nationalities, the difference between the EB-2 and the EB-3 will have had a high impact on the priority date backlog, but for the majority of the nationalities, the difference between EB-2 and EB-3 as far as waiting time for the final result is not that great. So the EB-2 is usually done for my engineer clients, doctors, lawyers, even people on the administrative side, executive positions. And my EB-3 are for my people that would require, for example, a nanny or someone that is a janitor or paralegal. All those positions will fall under the EB-3. Once the company has established there is a shortfall and a need to hire someone from abroad because the company cannot find a US citizen or a green card holder willing, capable, or available to undertake the position, the company has to start a process called PERM or labor certification, which is the labor market test to prove to the Department of Labor that the company can indeed go ahead and sponsor and offer this permanent position to this foreign alien. So the labor certification, the EB-2 and the EB-3 in that sense, is different from the other non-immigrant work visas because the green card is for a forward-looking position, for a position in the future. So a lot of people that apply for the EB-2 or the EB-3 are usually in the US with an H-1B visa, for example, or an E-3 Australian, or an H-1B1 for Singaporean nationals, or even J-1. And then the company offers a permanent position, and that's when the company has to go through the labor certification. So once the company says, okay, I have the shortfall for this position and I wanted to hire this foreign national because I know his work, or even if I don't know his work, I know he's willing to accept the position under the terms that I'm offering. And so the Department of Labor wants to ensure that the company is not tailoring the position, or the company is not trying to circumvent the system to bring someone and pay a lower wage, for example. So the company comes and say, I have this position, so we as legal advisors, we have to narrow down and of course articulate with the employer, the sponsoring company, what are the requirements for the position. That's the first thing. What are the true requirements for the position? Secondly, whether the foreign national has the qualifications such as education, experience, skills, knowledge that it's required for the position. Then third of all, because this is going to be an issue when you go to the um, immigrant petition phase, is to analyze whether the company has the ability to pay the salary that we believe the Department of Labor will come back saying that's the occupation that the position will fall under. And then based on this SOC code, which is the occupation, we say, okay, based on the complexity of the requirements for the position, we believe it's going to be, the Department of Labor will come back to a level 1, level 2, level 3, or level 4 wage. And then with that in mind, we can see the red flags that the company might face and try to resolve and articulate and change if required, if it's the actual need of the company to accommodate for what the company is looking for, and also for what the foreign national or alien is going to be able to provide with. So having that said, and having the minimal requirements in place, we ask the employee to get the educational documents and the experience letter from previous employers, because as a rule of thumb, usually the foreign national cannot use experience with the sponsoring company towards the minimum requirements for the position, unless the position being offered to the foreign national is at least 50% similar from the current position the foreign national has gained experience with. So for the minimum requirements, usually there are some requirements that would trigger an audit by the Department of Labor, for example, language, or if the requirements for the position as far as education and experience goes is beyond what the Department of Labor sees as normal. So the company would have to be ready to document business necessity if that's the case. Having all the foundation documents in place, then the real process with the government starts, which is filing the prevailing wage with the Department of Labor. As I said, is sending it to the government, essentially the Department of Labor saying, me as a company, I am sponsoring for the position of engineer or X, Y, and Z, and I need someone with a bachelor's degree plus 3 years of experience in mechanical engineering, for example, and they list the softwares or skills and knowledge that the position requires. In the Department of Labor, after analyzing that, it takes about 5 months or so nowadays, will come back with an occupational code and say, based on the metropolitan statistical area that your company is located and the qualifications that are required for the position, we believe the most adequate, the most appropriate SOC code for this position is this one, and that's the wage that you have to pay this foreign national. So at that point, if the company is paying less, for example, or the foreign national was offered a lower salary, then the company would have to make up its mind and decide whether the company is willing to pay this higher salary when the green card is issued. Remember, this is a forward-looking position, so the company doesn't have to pay the salary right now. It's just when the green card is issued. Or if the legal advisor in the company and the foreign national are not satisfied with the occupational code picked by the Department of Labor, then we can also request the Department of Labor to issue a redetermination, or we can always request another prevailing wage for a better occupation that we think the position will fall under too. But after having the salary in our hands, we can move forward with the recruitment steps, which are, as a minimum, posting the position for 30 days at the state workforce agency, putting the posting at least for 2 consecutive Sundays in local newspaper, posting the notices internally in the company's bulletin board, for example. And if the position is professional, meaning the position usually that it's within the PERM addendum, or usually that requires a bachelor's degree, then the company would have to run 3 additional recruitment steps, which are usually out of 10, and there are 10 listed by the regulations, but the most used 3 are, for example, the company's website, an internet like Monster, Indeed, LinkedIn, trade journal, or even on campus or radio. There are so many other types of advertisement that the legal advisor in the company would have to assess the risks of which is the most appropriate additional recruitment steps, and make a decision on how to run them. But everything is posted, then the company will start receiving resumes from candidates, and with that, when the company receives the resumes, the company would have to assess the resumes and only disqualify those candidates that are not US citizen or green card holders, or that do not have the education, experience, and skills and knowledge, the minimum requirements for the position. And if everything goes well and the company doesn't find anyone and has documented everything, because all that documentation will become part of the audit file of the company that has to be retained for at least 5 years. This is going to be covered very shortly. So after running 30 days of recruitment, then the company has to wait another 30 days for a silent period. It's called quiet period, where the company is still receiving resumes, conducting interviews, and making sure that there are no US citizens or green card holders out there in the labor market available, willing, or capable for the position. Then if there is none, the company then is going to get to the point of filing the labor certification, also known as PERM, with the Department of Labor. And it's that process is basically a summary of all the recruitment efforts that the company has been through. Nowadays, processing time for the labor certification is very quick. It's about a month, 2 months. I haven't seen 3 months the most. But if the Department of Labor doesn't want to audit the file, then with the certification in hand, the company, the foreign employee, can move forward to the second step of the green card process, which I'm gonna cover very, very soon. But if the file is audited, and that's when all that documentation for the recruitment efforts with the job ads, the resumes will have to be submitted to the Department of Labor. That's when we, as legal advisors in the company, would have to mail to the Department of Labor. And if everything is well, we usually take 6 to 8 months for the Department of Labor to review. And after review, if there is no issue, the Department of Labor can, of course, certify the PERM, the labor certification. Again, this audit file has to be retained for 5 years, and the company can still be audited after 2 years of having the labor certification or PERM certified. So now that the company has the labor certification certified by the Department of Labor, the company can then file an I-140 immigrant petition on behalf of the foreign national directly with USCIS, US Immigration and citizenship services. At that stage, what the company is proving to the US government is that one, the company has the ability to pay that salary that was set by the Department of Labor at the beginning of the labor certification, as I discussed, and that the foreign national has the qualifications for the position, meaning the education documents and the experience. At that stage, the employee can, or the company can also pay an extra premium processing fee to have the result within 15 calendar days. If not, then the company can just run its time and get the decision within the normal regular processing time. And then at that point, the priority date for those kinds of green cards are set when the labor certification is filed. So if the priority date, again, I urge you to refer to my video about adjustment of status and consular filing. So if there is a priority date is current and available, then the employee can go ahead and file for either adjustment of status or consular filing. After going through the regular processing, so something that I forgot to mention is that during the adjustment of status or consular filing application, what the USCIS or the consulate or embassy are looking for is whether the company still offers the position to the foreign national. And whether the foreign national or the alien has any inadmissibility issue that has to be overcome without waiver or not. If everything goes well, process is done correctly, then at the end, the foreign national will be issued a green card. Something to mention is if the I-140 has been approved and the adjustment of status has been pending for more than 180 days, there is a possibility under the regulations that this foreign national alien can port, which is transfer this green card application to a new employer, as long as the positions are substantially similar. So that's a very generic and very quick explanation of the EB-2, EB-3 process under the labor certification category. If you have any questions, again, myself and my team are available to answer your questions. My contacts are at the end of this video, and I hope you keep watching me. The next one, I'll probably do the EB-1 and the EB-2 self-sponsored green card applications in Portuguese. Thank you so much.